the Freedom of Information Act panel that we were creating, the bill that Mr. Greenberg and I presented last week. I pulled it down. Y'all didn't vote on it. Yeah. So anyway, the changes that we made, I think there's you can read through the amendment, obviously, as much as you want. I'll answer any questions on it, but I would say the substantive changes that we made were, number one, I listened to the committee's concerns. We replaced one of the lawyers on the panel with a non-lawyer. That person is a former custodian who has experience responding to Freedom of Information Act requests. So that's one substantive change that was made. Another was that Representative Davis raised a concern about whether the work of the panel would be subject to disclosure under the Freedom of Information Act. The concern there is not to protect the panel, it's just that if records are confidential, then you could, and they are deemed to be confidential by the panel, then you couldn't disclose their work on it without disclosing the records. And so what I suggested, and I think Representative Davis liked, at least for this particular concern, was if the decision of the panel is to make the records public, at that point you could submit a request for their work also on those records, because you're not disclosing any records that would not otherwise be subject to disclosure. And so if the records stay confidential, then the discussions about the confidential records stay confidential. If the records are made public, then the discussions about the public records can become public. So that's the second really substantive change. The third is we were trying to do two things with this panel, if you recall. One was to create a place where a requester or a custodian could appeal a decision and basically just have a free review by someone other than the custodian. And the second was to create basically a new balancing test for some of the exemptions listed under the Freedom of Information Act. There were quite a few concerns raised about that second part, the balancing test. I think they were fair concerns, and so that has been entirely removed from the bill. So there's no more singling out any particular exemptions. There's no new balancing test for any exemptions under the Freedom of Information Act. It's really just an appeal to this FOIA panel that's basically an objective, independent review of the basis for your request. And it'll be to apply existing Arkansas law, both as existing code and in case law. That's the third change. And then the fourth substantive change, which was raised by the chairman, which I think is also totally fair, is we don't really know what the workload of this panel will be. We don't know if everybody's going to request a review or if it'll be seldom or whatever the case might be. And so these are going to be volunteers, and we want to be sensitive to their time and concerns. And so it basically gives them the ability to deny a petition for review. And so they can just take the cases that they want to take. And that way they can manage their own workload, and that's totally up to their discretion. And so that fourth substantive change is in there. And then the last non-substantive change, which I think is noteworthy, is that the chairman's now co-sponsor of the bill. So I wanted to make sure and mention that to the members of the committee.
That's not always helpful in this committee. I've demonstrated that. All right, Representative Tosh, I don't know if you actually had a question or...
Thank you, Mr. Chair.